My name is Joseph Arvay. I was lead counsel in the case of Carter versus Canada, which is the case dealing with physician-assisted dying. Well, the arguments in the Rodriguez case were the arguments that one would have expected to be made at the time. It was in the early 90s. The charter was still a relatively new document in our legal landscape, and the evidence presented and the arguments made were all very good, but they have to be sort of viewed as a product of their time. There wasn't a lot of evidence in the case compared to what eventually became of the evidence in the Carter case. And the legal arguments that were advanced there were based on the jurisprudence at the time. And in the Carter case, of course, the jurisprudence had changed quite considerably since that time. I don't believe there were shortcomings presented in the argument in that case. I've heard that similar criticisms leveled, but I don't accept that they were valid. I don't think a different argument would have made a whit of difference in the case. The judges were all very, very smart judges, and judges will supply any deficiencies in the argument presented by counsel if they think there were deficiencies. All the judges considered all the relevant constitutional provisions. Rodriguez was a product of its time, and so was Carter. And the time was different for a whole bunch of reasons. The decision in Rodriguez was to uphold the constitutional validity of the section of the criminal code that made it a crime for anyone to assist someone with his or her death. The court split 5-4 in coming to that conclusion, but that was the essential conclusion of the court. I mean, it's possible that there could have been different and better evidence, but I don't think it really would have changed the outcome at all, because the majority was simply firmly of the view at that time that there was no constitutional right in question. Well, the charter contains an articulation or enunciation of various rights and freedoms. They're all cast very broadly. They're not sort of self-defining. It requires the judges to interpret them and define them. And they're very much a statement of our sort of fundamental norms and values. And those fundamental norms and values can evolve over time, not in short periods of time, but in longer periods of time. What someone might have thought was not protected by the right of, say, freedom of expression or freedom of association, over time, with more information, more evidence, more thought, those rights may be understood to protect conduct or activities that prior judges didn't think was the case. So the Supreme Court of Canada did not hold that Sue Rodriguez's rights were violated but were justified. The argument's a little more complicated. The Supreme Court of Canada recognized that Sue Rodriguez's right to security of the person was infringed by the law, but Section 7 of the Charter, which protects everyone's security of the person, doesn't do so in an absolute way. The state is allowed to deprive a person of their security of the person, or for that matter, their life or their liberty, so long as it's done in accordance with the principles of fundamental justice. The Supreme Court of Canada and Rodriguez, the majority held that even though Sue Rodriguez's right to security of the person and perhaps liberty was deprived by the law that prevented her from seeking assistance from a physician in death, was nevertheless done in accordance with the principles of fundamental justice. And so the court didn't even have to go to what's called Section 1 of the Charter to justify, for the government to justify that infringement. They eventually did, because of another provision of the Charter, the equality rights, but that really didn't play that much of a role in the Rodriguez case, except for Chief Justice Lemire. Justice Sapinka referred to the practice and laws and policies of other countries because, again, he was doing so in the context of what do the principles of fundamental justice call for. And he was also doing so, I think, because of one of the overriding provisions of the Charter, which is what rights can or should be infringed in a free and democratic society. And so I think he was sort of looking to the practice in Western worlds to help him inform the content of both Section 7 of the Charter, the right to life, liberty, and security of the person, principles of fundamental justice, as well as any justifications for any infringement in Section 1. You know, courts don't like to get too far ahead of public opinion, and nor do they like to be behind it. They'd like to sort of be right in sync, if you will, with sort of public opinion. And although talking about what happens in other countries in the world maybe doesn't really go to that point as much, but I think the Supreme Court of Canada at that time might have thought that it would have been going much further than a court should go, given that no country in the world, with the exception of Switzerland at that time, had legalized physician-assisted dying. I'm not sure if I can really put it any better than that. One of the reasons why he looked to see what other countries in the world were doing was because he was faced with an argument that this absolute prohibition against any kind of physician-assisted death was unconstitutional. He and the other members of the majority wondered whether there was any halfway measure between that absolute prohibition and a completely permissive regime. And he looked to all the countries in the world to see if there was any legislation which provided that halfway measure, which allowed some people in some circumstances to have access to physician-assisted dying without giving everybody in any circumstance the right to seek assistance in death. And he said in his reasons, he couldn't see any halfway measure, halfway house that would be workable. And he looked to all the countries in the world, and no one had one yet. And if we fast forward to Carter, by the time we argued Carter, there were a number of countries in the world. First, the European countries, Belgium, the Netherlands, Luxembourg, as well as Switzerland, and then the American states, Washington, Oregon, Montana, a South American country, Colombia. They had all now, not through the judicial process, but through the legislative process, enacted legislation that was designed to regulate physician-assisted dying. And that legislation sort of demonstrated that there could be halfway measures that would allow some people in some circumstances to have access to physician-assisted dying and without exposing people who were vulnerable to abuse. I completely agree with Justice Major's subsequent analysis of what happened, that the politicians of all stripes refused to go anywhere near it. This is one of those political hot potatoes that no party wanted to embrace as part of their platform. You'll need to talk to a political science as to why that might be. But it's almost precisely in those cases where the political process just simply dysfunctions. It's almost in paralysis, that it's so important that the courts use the Charter of Rights and Freedoms to protect the rights and freedoms of Canadians, because the political process, as Justice Major implied, just didn't work. There are certain issues which are, for some voters, single issues. You know, abortion, capital punishment, physicians is dying. And so, you know, again, you need to talk to political science rather than me, but there will be some people that would love to support perhaps a left-leaning party, except if that left-leaning party offends them on one of those single issues, and then they go to the other party. So anyway, I'm the wrong person to really talk too much about that. Well, Rodriguez was an important case because it's kind of planted the seed. We didn't get a plant out of it. We didn't get any fruit out of it, but it definitely planted the seed. Planted the seeds in the minds of people like me that one day we're going to take another run at this law. And like all charter decisions from the Supreme Court of Canada, like all decisions from the Supreme Court of Canada, the process is very incremental. A case decides this much about a particular provision of the charter, and it takes another case to sort of, move the chess pieces across the board. So Rodriguez was important in establishing, first of all, that a law that prevents someone from seeking physician assisted dying does deprive them of their security of the person and perhaps liberty. When we got to Carter, we could say, okay, well, that part's established. We got that established in Rodriguez, but we had to go further. The question is, how did it come about that I became involved in the challenge to the laws that prohibited physician-assisted dying? The answer is, I had been asked by the BC Civil Liberties Association to give a keynote address at a conference. I'm forgetting the year right now. I want to say it was December 2010. And I didn't know what to talk about. But my partner and I had been talking about Rodriguez quite a bit over the course of our relationship for a number of different reasons. Notably, my mom was suffering horribly from various illnesses, and I couldn't stand watching her suffer. And of course, the idea of Rodriguez being an impediment to having her have a peaceful death weighed heavily on my mind. Likewise, my very best friend Larry had recently died of Lou Gehrig's disease, the same that Sue Rodriguez had. So I had in my mind that the law had to change. And when I had the opportunity to give this keynote speech to the people attending this conference, I thought I would make the subject of the speech essentially a challenge to the BC Civil Liberties Association to relitigate the Rodriguez issue. After I gave my speech, the executive director of the Civil Liberties Association came up to me and said, we're in, let's do it. So that's how it started. It was definitely personal for me, and I believed it would resonate with just about every Canadian, because I think just about every Canadian either knows someone who has died an ugly death, or fears for themselves or their family or friends that may befall them. I thought it was an issue that would be one where there would be overwhelming support. I knew that, having said that, I knew that I was embarking upon a case that would be very contentious, at least legally, and also, I suppose, socially in some sectors. But I also thought that the time was right to bring this challenge. If someone had said, let's bring it a week after the Supreme Court of Canada decided Rodriguez, I would have said, that's ridiculous. I think if someone had said, let's bring it 10 years after Rodriguez was decided, I would have said, the time's not right. I had a sense that the time was right 20 years later. Of course, one important thing that had changed that I alluded to earlier, which is that there were now countries in the world and states in the United States which had legalized physician-assisted dying, albeit through the political process, the legislative process, not the judicial process. And that was an important distinction for me to keep in mind, because any court that had considered the constitutional validity of physician-assisted dying, whether it was the Supreme Court of Canada in Rodriguez or the U.S. Supreme Court in the case there, or the English High Court in the case there, or the Irish High Court in the case there, where all of those high courts, all of those Supreme Courts upheld the prohibition, the message from the courts was, we need to defer to what Parliament wants to do. This is a matter for Parliament. This is a matter for the legislative process. This is not a matter for the courts. So I was alive to that distinction. And of course, I was worried that if we started another Rodriguez-type case, we might get the same result, that even though there were these initiatives in other countries and states to legalize physician-assisted dying, that the court might say, yes, that's the way to get to where you want to go, i.e. through the legislative route and legislative process, not the judicial process. So I was alive to that being a possible problem. But on the other hand, I had very much in my mind what Justice Sapinka said in Rodriguez, that there was no halfway house between a regime where you have an absolute prohibition on physician-assisted dying on the one hand, and on the other hand, a totally permissive regime. When I saw that there were permissive regimes around the world, albeit through the legislative process, I thought that would be a very, very important component of our argument as to why the Rodriguez decision was no longer binding. That was one reason at least. I believe that public opinion has shifted, that there was now a groundswell of support for physician-assisted dying that didn't exist back in 1992 or 4, whenever Rodriguez was decided. I also believe that the jurisprudence under the Charter had evolved considerably to give us legal arguments that were not available in the Rodriguez case. One of the issues in the Rodriguez case was whether there was any moral or ethical distinction between what the Supreme Court of Canada called passive euthanasia versus what they called active euthanasia. What they referred to as passive euthanasia were the many end-of-life treatments that were considered completely lawful in Canada, indeed around the world. The ability of a patient to withdraw, say, life-sustaining machines, such as a ventilator. The ability of a patient to seek palliative sedation. The ability of a patient to refuse artificial hydration or nutrition. The ability of a patient to ask the doctor to give me as much morphine as I need to make the pain go away without asking the doctor to kill him or her, but everybody knowing that too much morphine is going to result in the death of a patient. The court said that all of those examples that fell within the rubric of passive euthanasia was not only lawful, but it was moral, it was ethical. The court said, on the other hand, active euthanasia, where a patient asks a doctor to provide a lethal injection with the intent to kill the patient, that was had always been unlawful, had always been immoral, and should remain that way. And the court said that was sort of the Rubicon that the court shouldn't cross. And I thought about that for a long time, and I thought, that's a Rubicon that we should cross. And one of the most important witnesses, I shouldn't say the most important witness, one of the very important witnesses in the case was actually a philosopher from the University of Toronto by the name of Professor Wayne Sumner. And I had read a piece that he wrote in the Walrus magazine, and eventually a book that he had written. And I persuaded him to come to testify, to try to persuade the court that this so-called ethical distinction between active and passive euthanasia made no sense at all. And he came and he testified, and the trial judge agreed with him. And her finding that there was no ethical or moral distinction between active and passive euthanasia really sort of robbed the Rodriguez decision of its sort of philosophical underpinning. I think that was a very important part of the case. Another reason, if I can keep going on, that we thought that the result might be different is that the court in Rodriguez simply didn't seem to think that a physician could properly assess the competence of a person seeking physician-assisted death, the voluntariness of their choice. Now, that might be because there really wasn't that much evidence of that in the Rodriguez case. But we made a point of making sure that our trial judge would have the evidence of physicians about their ability to assess the competence, the voluntariness of patients in making these decisions. And then perhaps finally, one of the things we did differently in Carter from Rodriguez is we didn't want to focus on just one patient. It's true that Gloria Taylor was our lead plaintiff and the person who was the face of the case, just as Sue Rodriguez was. And that's important, I think, to garner public support and sympathy for our plaintiff. But we made sure that the court heard the evidence of many, many people who were experiencing horrible illnesses or diseases and wanted physician-assisted dying, or their family members who talked about the process of death and dying for their loved ones. We called people from across Canada. We called people from around the world to testify about their experience with these kind of illnesses, to sort of demonstrate the breadth of the problem, and one that this was a case that was going to affect all Canadians. It wasn't just one person. The testimony of our lay witnesses was profoundly moving. The Crown accused us of trying to inflame the passions of the trial judge, you will, by what they called our blood and excrement evidence. And that's what it was, because that's the reality of people who suffer from these kind of diseases. We wanted to make sure that the court had that reality front and center before it, and not just the evidence of experts, of which there was much, but which could tend to sort of sterilize, sanitize the real issue. So the Crown tried to prevent the court from hearing that evidence, but the trial judge would have none of that. I sometimes say that in every case, there's sort of a moment of epiphany. And I definitely had that in the Carter case. In the beginning, I thought our case was about the right to liberty and the right to security of the person. And I thought the Crown's case was all about the right to life. And of course, when you think about it, the right to life is a pretty profound right that probably trumps, in most people's imagination anyway, the right of liberty and the right of security of the person. The Crown's argument was this law was designed to preserve life. And when you think about it, that's a pretty darn good argument. And I was always worried that the Crown's right to life would trump, I hate to use that word, the rights to liberty and security of the person. But my epiphany occurred when I realized that we actually had the right to life on our side. And I'll explain why that is. It became apparent that many people had to choose between committing suicide or asking family or friends to assist them with their death when they still were enjoying their life. Because if they waited too long to the point where life no longer had any value for them, or living was worse than death, then it would be too late. And then they would simply now have to endure a lifetime of grievous suffering. And so the evidence before the court was that some people actually did opt to commit suicide or to seek the assistance of others at great risk to those people for criminal prosecution, rather than suffer. And other people, of course, didn't do that, but opted to suffer. But the Supreme Court of Canada, in the very first paragraph of its decision, recognized that this legislation kind of presented those individuals with the cruel choice of either dying sooner than they needed to or wanted to, or suffering for a very long time. And so we were able to establish that this law actually contributed to death, contributed to people losing their life, which meant that we actually had a legal argument that this law not only deprived people of their liberty and security of the person, but deprived them of their life. And given that the Crown's argument was that we should have zero tolerance for any wrongful deaths, we were able to establish that actually this law was causing many wrongful deaths. So that was, in my view, the turning point in the case. Our challenge in the case was to strike down this law. That's all the court could do, was either uphold the law or strike it down. But we appreciated that there needed to be something to replace that absolute prohibition, the so-called halfway measure that Justice Sapinka said wasn't possible in the Rodriguez case. And our view was that there was no need for an absolute prohibition because one could devise a regulatory scheme that would protect vulnerable people. It wasn't for us or the court to rewrite that law. That was for Parliament. But we did say to the court that in any law must have these sort of minimal rights for Canadians. There must be a right for an adult who is competent, who voluntarily seeks physician-assisted dying, to have that right when they suffer from a grievous and irremediable illness. We said that was the core of the constitutional right at issue. So the court could strike down the law and make it clear to Parliament that if they wanted to have a regime that still prohibited some people from seeking assistance in suicide, they couldn't prohibit an adult who was competent, voluntary, suffering intolerably or irremediably from seeking assistance in suicide. We had 4 plaintiffs. We started off with the BC Civil Liberties Association as the institutional plaintiff, but I don't quite remember the sequence, but eventually we were approached by Lee Carter and her partner, who told us about their mom having to go to Switzerland. And we thought they would be a very good plaintiff because even though it wasn't their right, their liberty was at risk, just by virtue of having assisted their mom to go to Switzerland. They felt in some kind of legal jeopardy. And you need, in order to be a good plaintiff or a proper plaintiff, you have what you need what the law calls standing. You have to have the skin of the game, to put it in simple terms. And because their liberty was at risk for just helping their mom go to Switzerland, they would have had standing. The Civil Liberties Association was a public interest organization, and we had established in an earlier case involving downtown East Side sex workers that they would have had standing too. But we still wanted to have a plaintiff that was more directly affected, and that's where Gloria Taylor came in. And she came in after we filed. She heard about the case. She contacted us. We met with her, and as soon as we met with her, we realized she was the perfect plaintiff. The BC Supreme Court decision, the trial decision, came down on June 15th, 2012. We were obviously very anxious about what that decision would be. The court put an embargo on the release of the decision for 2 hours to give counsel on both sides an opportunity to read the decision. So we were locked in a room for 2 hours reading this massive decision. It was like 400 pages long. And needless to say, we were ecstatic with the outcome because it was a very hard-fought trial. The government put forward a very vigorous case. They had their own experts who presented evidence that could have persuaded the trial judge to uphold the law, but she didn't, and her decision was methodical in addressing every one of the possible arguments, both pro and con, for the issue, and she then made findings of fact on all the important issues that went in our favor, as well as findings of law. We knew this was just step one in a three-step dance. We knew that the government would appeal to the Court of Appeal, and we knew that whoever lost there would appeal to the Supreme Court of Canada. And although nobody has a right to a hearing in the Supreme Court of Canada, this was one of those cases where we were all very confident that the Supreme Court of Canada would hear this case. So the government appealed it on a number of grounds, but the main one was that the Rodriguez decision was binding on the trial judge and binding on the Court of Appeal, and that therefore the law could not be struck down other than by the Supreme Court of Canada, but that the trial judge had no business not following Rodriguez, and the Court of Appeal likewise would have no business not following Rodriguez, and therefore the Court of Appeal should allow the appeal. When it was my turn to present the argument in the Court of Appeal, I said something to the effect, surely judges, surely justices, you don't need to hear me on the argument that you're bound by the Rodriguez decision. And one of the justices of the Court of Appeal said, surely, Mr. Arvay, we do need to hear from you. And as it turned out, the Court of Appeal, a majority of 2-1, allowed the appeal on the basis that neither the trial judge nor the Court of Appeal could come to a different conclusion than the Supreme Court of Canada in the Rodriguez case. So in other words, the appeal was allowed on the basis of this hoary ancient doctrine called stare decisis, or in English, the law of precedent. I've never been one for worrying too much about precedent. I always thought you put forward a case where justice cries out for a particular result, and you show the judge the path, how to get to that result, that prior cases shouldn't be the end-all and the be-all of the argument. But the doctrine of stare decisis or precedent is a very powerful doctrine in Canadian law, and it became a roadblock at the Court of Appeal. But I wasn't concerned about it in the Supreme Court of Canada because everybody knows the Supreme Court of Canada can change its mind, and that's what it did. We were obviously disappointed in the decision of the BC Court of Appeal. I was actually surprised that they would feel that the Rodriguez decision was so binding. I really didn't think that that would have been the basis for their decision. But to some extent, I was relieved that that was the basis for their decision, as I reflect on it now, because it was the weakest basis going into the Supreme Court of Canada, because of course the Supreme Court of Canada wasn't going to be bound by its previous decision. So if I had to lose in the Court of Appeal, that was the best way of losing. And there was a powerful dissent by Chief Justice Finch, who had accepted the views of the trial judge, and whose views I knew would probably be influential in the Supreme Court of Canada. When we started this case, we knew that it wasn't going to be over until we got to the Supreme Court of Canada. But that doesn't mean that the first levels of the trial decision wasn't important. It was critical, because in any case, there are issues of fact and there are issues of law. The trial judge is all important on issues of fact. If we had lost the case before the trial judge on the facts, we would not have succeeded in the Supreme Court of Canada. But because the trial judge made so many findings of fact in our favor, we knew that the appellate courts, including the Supreme Court of Canada, would be very deferential to those findings of fact. And that's what, in fact, was the case. Once the trial judge made findings of fact that doctors could reliably assess, for instance, the competence and voluntariness of a patient, once the trial judge made findings of fact that these other regimes around the world were working effectively, once the trial judge made findings of fact that there was no real ethical distinction between passive and active euthanasia, these were all findings of fact that the Supreme Court of Canada would defer to and did defer to. And so the only job of the Supreme Court of Canada was really to determine what the law required. And I was confident that the way the jurisprudence was moving with respect to Section 7 of the Charter in particular was moving all in the right direction for us. And so our focus in the Supreme Court of Canada simply had to ask them, A, to be very mindful and indeed deferential to the findings of fact by the trial judge, and then to continue to interpret the Charter as they had been in a very progressive way. I've done a lot of important cases, but this was clearly the most important case of my career. And I believed it was one of the most important cases for the Supreme Court of Canada. And I remember saying something to the effect that this is a momentous day. And that because I understood how profound the issues were before the court and how significant the implications were, win or lose. I think the Crown's main point had many points, and I don't want to reduce them in a way that would sort of simplify them. But one of the Crown's main points was this was a matter of complex, controversial public policy that should be left for Parliament. I think that was the essence of the Crown's argument, and that this is just a matter that should be left for Parliament. Parliament's had untold opportunities to address this issue. And as I alluded to earlier, Parliament simply wasn't dealing with it. The political process itself was dysfunctioning here. It wasn't addressing the rights and freedoms of Canadians, and it was for the court to do so. The Supreme Court of Canada is pretty rigorous or tough on counsel when it comes to arguments. We're only allowed an hour in total to make each side's argument. And then we all had interveners who were allowed their 5 or 10 minutes. So I think the appeal was finished in a half a day. And then I think it took them about 6 months. I was back in BC, but my co-counsel were in Ottawa. And again, it was a similar situation where they were locked up in a room for an hour or so to read the decision, and I was in Vancouver doing the same. It was comparable to what happened at the trial level, but magnified, because now we knew we won, it was over, and we had accomplished what we set out to accomplish. Great emotion. I guess can't put it any better than that. It was a very emotional moment in my life and in my career. The Dr. Lowe, video was played over and over again. And I think it helps again sort of to get sort of public opinion on side. But I don't want to sort of overplay the significance of public opinion. It's not insignificant. As I mentioned earlier, courts don't want to get too far behind, nor do they want to get too far ahead of public opinion. Courts want to decide the case based on the evidence and the law. I think I can say that, and this perhaps is an answer to your question, what was my reaction to the Supreme Court of Canada decision? I had an emotional reaction because I had invested as my co-counsel and my clients an enormous amount of time and emotional energy into pursuing this case. At some risk to all of us, we were doing something that a lot of people thought could not be done. So there was something we were obviously very satisfied that we had succeeded in this case. But the other reaction I had was one of true pride in living in a country with such a progressive Supreme Court. The Supreme Court of Canada did in Carter what no other Supreme Court in the world had done, or done since. And I, as a constitutional lawyer, was really very proud that I was a member of a bar that could plead a case like this before our Supreme Court and get the result that we got. So what happens next is that Parliament is given a year to come up with a new law. And at that time, the Conservatives were in power. By the time the October of 2015 came about, there was the election, and there was still no new law. And then the Liberals were in power, and they wanted to have a further 6-month extension to draft a new law. And so they asked the Supreme Court of Canada for that extension. And we opposed that extension. We opposed it because we didn't think they needed any more time, that they were just dragging their feet in the process of enacting the new law. The new law wasn't going to be very complicated. For one thing, it was the Supreme Court of Canada and Carter had pretty well set out what the new law had to look like. And I don't recall the details, but there were committees that the government set up to consider the new law, and they made it pretty clear exactly what needed to be done. But the government, in our view, was simply taking too long. It's one thing, it wasn't just about how long it takes to enact a new law. The fact of the matter, there were people suffering. And so that's why we decided that we was first, oppose any extension, but if an extension was going to be granted, that we wanted to make sure that in the meantime, the people whose constitutional rights were recognized in the Carter case had those rights respected by the government, by the courts, by virtue of the court giving them the right to seek physician-assisted dying pending the new law. So, in a nutshell, we opposed the extension because we didn't think Parliament needed as much time as it claimed it needed. And we also opposed the extension because, contrary to some people's thinking, it wasn't going to be catastrophic if there was no law, because the matter could be dealt with by the provincial colleges of physicians and surgeons. And Ontario, for instance, at that time was ready for a regime where there was going to be no law. They had rules and guidelines in place to tell doctors what they could and couldn't do, and other provinces would have followed, of course. So we opposed the extension because Parliament was dragging its feet. It didn't need that much time. It wasn't going to be that problematic if there was no law, because the vacuum would be filled by rules and guidelines and policies of provincial governments and colleges of physicians. And finally, the delay of Parliament was going to cause continued suffering, intolerable suffering, for Canadians who had already obtained the right to physician-assisted dying, and we didn't think their suffering should be further contemplated. But the Supreme Court of Canada gave the government a further 4 months to enact the new law. But the Supreme Court of Canada did something that again was precedent-setting. The Supreme Court of Canada said that even though Parliament could have another 4 months to enact the law, in the meantime, it said that all Canadians who would otherwise meet the requirements of physician-assisted dying set out in the Carter decision could apply to judges in their various provinces to have an order that they could seek physician-assisted dying while Parliament was drafting this new law. That was, again, a very important decision. So then what happened after the 4 months expired, Parliament did enact a new law. The Supreme Court of Canada indicated that any law should allow an adult who is competent, who voluntarily seeks the assistance of a physician in dying, should have that right so long as that person has a grievous and irremediable illness. Full stop. The Supreme Court of Canada did not add any further limitation on the right, such as that the patient has a terminal illness. That was largely because we were very determined at the very outset when we started the case not to confine the right to people with terminal illnesses. That was the case of the laws in Washington and Oregon. You had to be terminal. In other words, your death had to be about 6 months away. When we were conceiving of of the case and what the ultimate result should look like, we put our mind to that. We wondered whether or not we should limit our argument to those with terminal illness, because after all, we were asking the court to do something that it had never done before, and we didn't want to overreach. We wanted to be pragmatic in what we thought was doable. But we had in mind many people whose illnesses were not terminal. And one man in particular was a man by the name of Tony Nicholson, who had gone to Greece on a business trip, and he was felled by a stroke, which left him in the condition called locked-in syndrome, which meant that he could not move any muscle in his body other than his eyeballs and his eyelids. And he was able to blink out an affidavit using a computer, one blink at a time. He was able to provide the court with an affidavit using this computer where he blinked out one letter at a time, in which he described the horror of living in this condition for the rest of his life. And his life expectancy was probably 20 years. When we thought about people who might be trapped in their body that way for 20 years, suffering intolerably, we thought there's no place for a requirement of being terminal. One might even imagine that someone might be able to tough it out, if you will, for a few months of suffering. But we thought what was just beyond acceptable, that someone would have to suffer for that long. So right from the get-go, we said the right to physician-assisted dying should not be limited to people whose condition is terminal. The trial judge agreed with us. The Supreme Court of Canada agreed with us. And what did the Parliament of Canada do with the new law that it enacted? It imposed a terminal requirement. It didn't use that word. It used the word something to the effect that one's natural death must be reasonably foreseeable. And that we consider to have tainted an otherwise decent law, a law that otherwise was going to respect the decision of the Supreme Court of Canada. We believe that the law is actually contrary to the Carter decision, does not respect the decision of the Supreme Court of Canada, and is unconstitutional. And we have started yet another lawsuit challenging that law. I'm a disabled man. I was very alive to the arguments of the disabled rights groups, but they were misguided and wrong because the disabled rights organizations, in their sort of zeal, if you will, to protect disabled people from being somehow persuaded or cajoled to accept death rather than life, I think fail to understand that all disabled people have agency and autonomy and independence, and they should be able to exercise the right to choose physician-assisted dying as any other non-disabled person. But I think the government of Canada caved into their arguments. There were arguments that were advanced at the trial. They were rejected by the trial judge. They were rejected by the Supreme Court of Canada. And in my estimation, they will be rejected again when our challenge to the new law is decided by the court. We brought another constitutional challenge. It's before the BC Supreme Court. It's working its way through. It'll probably take 2 or 3 years, and untold people will have to suffer.